Jai Hind everyone. Welcome to my YouTube channel, which is Explore Yourselves, Banking, and General Knowledge, etc. Today I am going to describe about gift deed versus sale deed versus will. How to choose the right way to transfer property. Complete guide. Introductions. Transferring property is one of the most important financial and legal decisions a person can make. Whether you want to gift a property to your children, sell it to a buyer, or ensure that your assets are distributed according to your wishes after your lifetime, choosing the correct legal document is essential. The three most common methods of transferring ownership are gift deed, sale deed, and will. Each serves a different purpose and comes with its own legal requirements, benefits, drawbacks, tax implications, and level of protections. Understanding the differences between these three methods can help avoid future disputes, unnecessary taxes, legal complications, and delays in transferring ownership. Here is a comprehensive guide to help you make an informed decisions. What is a gift deed? A gift deed is a legal document through which the owner voluntarily transfers ownership of a property to another person without receiving any monetary consideration in return. It is commonly used to transfer property to close family members such as children, spouse, parents, or siblings. What is a gift deed? Key features. Transfer takes effect immediately after registration. No payment or consideration is involved. Must be accepted by the recipients during the donor's lifetime. Registration is mandatory under the Registration Act. Stamp duty is payable and varies from state to state. Once executed and registered, it is generally irrevocable except under limited legal circumstances. Advantages. Immediate transfer of ownership helps avoid inheritance disputes, useful for estate planning during one's lifetime, suitable for gifting property to family members, legally strong once registered. Disadvantages. Cannot usually be cancelled after registration. Stamp duty can be substantial in some states. Donor loses ownership immediately. May have tax implications depending on the relationship between donor and recipient. Is suitable for parents gifting property to children, gifts to spouse or close relatives, estate planning while alive. What is a sale deed? A sale deed is a legal agreement through which ownership of a property is transferred from the seller to the buyer in exchange for a mutually agreed consideration sale price. It is the most common method used in property transactions. Key features. Transfer is made against payment. Registration is compulsory. Stamp duty and registration charges apply. Buyer receives legal ownership after registration. Seller loses ownership upon completion. Advantages. Provides clear legal ownership. Financial consideration is received by the seller. Widely accepted by banks and financial institutions. Suitable for buying and selling residential, commercial and agricultural properties. Disadvantages. Higher stamp duty and registration costs. Capital gains tax may apply to the seller. Requires through legal verifications and documentations. Can involve lengthy paperwork. Best suitable for buying or selling property, commercial transactions, and investment property transfers. What is a will? A will is a legal declaration through which a person specifies how their property and assets should be distributed after their death. Ownership does not transfer immediately but only after the testator passes away. Key features. Effective only after the death of a property owner, can be changed or revoked any number of times during the owner's lifetime. Registration is optional but recommended. No stamp duty is payable. Executor administrators distribution according to the will. Advantages. Full control over property during lifetime, can be modified whenever circumstances change. Low cost compared to other transfer methods. Useful for comprehensive estate planning. Can specify different beneficiaries for different assets. Disadvantages. Ownership transfers occurs only after death, can be challenged in court by legal heirs. Probate may be required in certain cases or jurisdictions. Family disputes may arise if the will is unclear. Base suitable for estate planning, distribution of assets among multiple heirs, individuals wanting to retain ownership during their lifetime. Features: transfer timing, gift it and sell it immediate, will is after death. Consideration: gift it no, sell it no, will is no. Registrations: gift it mandatory, sell it is mandatory, in will optional. Stamp duty applicable for gift it and sell it, not applicable for will. Ownership during lifetime, gift it lost immediately and sell it also, written in will. Can be changed later. Through in gift it generally no, sell it no, will yes. Tax implications. Gift it may apply, sell it tax capital gains may apply, will generally no transfer tax at execution. Suitable for gift it family members, sell it property sale, will estate planning. Tax implications. Gift it. Gifts received from specified close relatives are generally exempt from income tax under Indian tax law. Gifts from non-relatives above prescribed limits may attract tax in the hands of the recipient. Stamp duty remains payable as per state laws. Sale deed. Seller may be liable to pay capital gains tax. Buyers pay stamp duty and registration charges. TDS provisions may apply for high value transactions under applicable tax laws. Will. No tax is payable merely for making a will. Beneficiaries generally inherit property according to applicable succession and tax laws. Future sale of inherited property may attract capital gains tax based on prevailing rules. Which option should you choose? Choose a gift deed if you want to transfer property immediately, the recipient is a trusted family member, you no longer wish to retain ownership. Choose a sale deed if you want to receive payment, you are selling property legally, it is a commercial transaction. Choose a will if you want full control over the property during your lifetime, you want the transfer only after your demise, you may wish to change beneficiaries in the future. Important points to remember. Verify the property's legal title before any transfer. Understand the applicable stamp duty in your state. Ensure proper registrations whenever mandatory. Keep all original documents safely. Consult a qualified legal professionals for complex family or property matters. Consider tax implications before finalizing the mode of transfer. Clearly document the intentions to reduce the risk of future disputes. Conclusions. Choosing between a gift deed, sale deed, and will depends entirely on your objectives. If you wish to transfer ownership immediately without consideration, a gift deed is appropriate. If the transaction involves payment, sale deed is the correct legal instrument. If your goal is to retain ownership during your lifetime while deciding how your assets will be distributed after your death, a will offers the greatest flexibility. Each method has distinct legal, financial, and tax consequences. Taking informed decisions today can safeguard your family's interests, reduce the likelihood of litigations, and ensure a smooth transfer of property in accordance with your wishes. Disclaimer: this content is intended solely for general educational and informational purposes. Property laws, stamp duty, registration requirements, succession law rules, and tax provisions may vary by state and are subject to amendments. The information provided should not be treated as legal, financial, or tax advice. Before executing a gift deed, sale deed, or will, consult a qualified advocate, chartered accountant, or legal professional to evaluate your specific circumstances and ensure compliance with applicable laws and regulations. Thank you very much for your patience. Request to like, subscribe, and share.